Morning, gentlemen. My name is Scott Gates, and I'm here today to the consideration of the positions that are going to be considered for appointment late last night. I forwarded the commissioners and the AG opinion, and that one was about a constable appointment with the Attorney General. It was signed by John Cornyn. Said that there's no rush, gentlemen. He made a really articulate case where it says that you shall appoint, but that's only relevant to the authorization that the court is the one that makes the appointment. But there's no rush. In fact, in that Attorney General's opinion, he makes a really good case that it would be contradictory for the law to require you to do something in a hasty manner, and that when it comes to the appointment for county judge and county treasurer, prudent deliberations are in order. Secondly, while the Texas Open Meetings Act may provide for interview of applicants or consideration in closed session, I would ask the court to hold as much of this as possible in open session, because I think the people have a vested interest in who's appointed. And I think that even though the wording of the law says that you can, doesn't mean that it's prudent or that you even should hold the selection process, interview process, or whatever else is involved in consideration of the appointments in closed session. And I would encourage the court to conduct that in an open and transparent manner, because again, I believe that the people have a vested interest in knowing as much as possible about who's appointed in this hasty manner. There really hasn't been a vetting process. There's very little information out there. So, thank you, gentlemen. Thank you.
Did the McLennan County Commissioners Court break the law earlier this week? We'll ask Commissioner Kelly Snell about that next here on News Talk 1230, The Talk of Waco. There was, quote, "It was an agreement that the vote that we took in public was a unanimous vote because we don't want to put anybody behind the eight ball that's coming in, and we agreed to do that. We had our private vote in executive session, but we go with the court's will and the court's desire." The first question, you seem to indicate that there was a vote behind closed doors, which is a violation of open meetings laws. Did that happen?
No, I can tell you, we can't say what happened in executive session, but I can tell you what didn't happen is we didn't have any voting, and it was a poor choice of words. We had a long day. We were trying to get everything done, and I should have stated private deliberations, because that's all we did is deliberate. When this thing started, Shane, before we even took any applications at the forefront, we had a gentleman's agreement, a consensus that we would give all the support we could to the candidates that were chosen to replace these open positions. So the Trib came to me, and I had openly supported Stacey Stone in the newspaper on GOP for me. I said, that's the one that I thought would be a good candidate. But, in the course of deliberations, when we were through and everybody's deliberation had taken place in executive session, and we came out, when people hear people deliberating, they kind of know where the support lies. So, Commissioner Perry made a motion to bring in Scott Felton, and it was seconded and passed. I mean, somebody could have put somebody else up that thought they had it, but, that one passed. And then I think Commissioner Gibson put up Bill Helton, and it was seconded and it passed. I mean, I could have possibly put Stacey Stone's name up, but why? It wouldn't have got a second.
But so the only reason that whoever motioned for these people to be appointed did that is because, as you mentioned, you knew ahead of time who was going to get the job. You say deliberations, you say you misspoke to the paper, but whether you formally took a vote or not, something had to happen in that closed-door session out of the public light for you guys to agree on a candidate, and isn't that effectively a vote?
Well, I wouldn't think so, Shane, because we don't take a vote. And like I say, if you've got 5 people deliberating, it's pretty easy to tell which, some people that like 3. It all takes 3. 3 votes is the will of the court. So, and all that was done in executive session. And personally, if it was up to me, I would like to have the interviews and everything done in open court. But as our legal advice was, it was best to do all that behind closed doors in executive session because it did have to do with employees and applicants.
I think the paper also said that was there an attorney in that executive session?
No, we normally don't have attorneys in executive session because, we don't have an actual county attorney. We use an attorney firm, but, when they're there, they're charging the county for it.
Okay.
And Jim's pretty good about keeping the court on the right track.
All right, one other question on the vote or the non-vote or the consensus, and somebody's listening right now. Lots of people are listening right now, and what their first reaction is to what you just said is, well, he just changed his word. And I'm not blaming you. You're just the one who was rightly or wrongly upfront to the paper about it. And I have reached out to other commissioners to try to get them on the show, and we'll see if we get some of them on next week. But what somebody hears when you say that it was consensus and that you kind of know which way, what they hear is you guys did something behind closed doors that you weren't allowed to do regardless of what you call it.
Well, and I wouldn't call it a consensus. Like I say, it's deliberation, and when you've got 5 people deliberating about something, a football game or whatever, you can pretty much tell them, if there's 3 people that have a similar view.
Okay, and so to figure that out, you had to have made, not you, the court had to have made that decision. There's at some point you realize that a consensus has been reached. Reaching that consensus behind closed doors, is that not a violation?
And like I say, I don't know that you'd say it's a consensus. You have deliberation that goes on, and then once everybody's through deliberating, we could have gone out, and we couldn't have got a second on anything. I mean, you don't know until the actual vote's taken. I mean, you're not sitting behind closed doors saying, okay, we got enough. Everybody deliberates, you go out, and if somebody feels like that they felt out of the discussions that happened in there that this person would be the one, and it just so happened that, they did because the first 2 that came up were voted in.
Well, and that's again,
and second
somebody,
is the main thing.
Right, but somebody listening is going to say, well, that wasn't just pure coincidence that out of 16 applicants or whatever the number was, that it just so happened that the person that you guys decided on was the first one to come up and they just so happened to be voted in.
And I think we only had, at the end, there was 3, I think, for judge, and I think there was only 2 for treasurer.
Okay.
That made the final portion of the deliberation after we, because we interviewed, I think, 3 and 2, I think is what it was.
Okay. Kelly Snell's with us. He's one of the county commissioners, Precinct 1, here on News Talk 1230. Let me move to the other issue, and that is this notion that the court wanted to have a unanimous level of support for these new candidates. You mentioned that whoever comes in is going to need the support of the court, and they're going to take on these jobs. Well, one of the guys taking over just left the post 2 years ago. That's Bill Helton for treasurer. The other guy who's taking over as county judge, Scott Felton, has been intimately involved in this community for decades. Why is it necessary to treat these guys as if local politicians use executive sessions for all kinds of crap that you and I should know about? And now they are able to say, well, the attorney says we can't say anything because it was an executive session. Well, that's convenient, isn't it?